The U.S. Justice Department just came out, issued new guidance for all of those pesky states doing audits on the 2020 elections. The DOJ, being headed up by Merrick Garland, now announced that there's going to be some oversight. We have our eyeballs on you, states like Arizona, the states doing the audits. Let's take a look at what's happening here. Some people are viewing this as a warning, and we're going to give a shout out over here to AZ Central here in Arizona because we have a big audit going on right now. Now, we're not going to be talking about that specific audit, but just about these new guidelines, because the guidelines now, in my opinion, are out here to chill these. It's to stop these from going forward. It's to put a little bit of fear in the people who are promoting the audits or who are trying to encourage them to be done. It's for the senators, but it's also for the private companies that are doing these things. And specifically, I'm talking about companies like the Cyber Ninjas who have been doing these audits. The DOJ came out and said, we're watching you punks over there. If you think that we don't have eyeballs on you, you have another thing coming. And in fact, this could be something that is even criminal in nature if you screw up, if you cross that line. So the DOJ is really putting the spotlight down on a lot of these audit companies. Why? Probably so that they don't do audits anymore, right? Probably to chill that efforts. All right, so let's get back into it. Some background here before we jump right into the document itself. U.S. Justice Department on Wednesday issued new guidelines. Move came 3 months after Arizona Senate began its review here in our state. Guidance outlines federal laws that pertain to election audits and talks about chain of custody records and protocols. We're going to read the article. We're going to read the guidance. While the department described the documents as guidance, they also serve as a kind of warning about what the federal government will and will not tolerate as part of these reviews. The documents only mention Arizona's efforts once in passing, but they follow an earlier letter sent to the Arizona Senate that raised concerns about what's going on here. Merrick Garland, the new attorney general under Biden, said the right of all eligible citizens to vote is the central pillar of our democracy. Justice Department will use all the authorities to zealously guard that right. Okay, so before we dive into this, this is the document. This is what it looks like. It is the federal law constraints on post-election audits. Now, you see what they did here? They put audits in quotation marks. This little is very clever. They think they're very clever. Published July 28, 2021. And so they're going to say, oh, these so-called audits. You call it an audit. We call it audits here at the Justice Department, which is, a little bit rude, quite frankly, a little bit rude way to start off a memorandum. But we also have to keep in mind what's happening here. Remember, we've got a federal system of government. We have state governments. We have feds and localities. Now, back during the election, there were a lot of battles about that system. And we had a lot of problems with this in all of the preceding election litigation. So let me frame that out a little bit better. If you recall, there were a lot of changes that took place in the various states all throughout the country. We talked a lot about Pennsylvania. We talked a lot about North Carolina and many of the other states that sort of had some changes taking place before November 3rd, 2020. Specifically, Pennsylvania moved the election date back. North Carolina moved it back. We saw some other changes about how ballots can be collected, how people can register to vote, and what sort of signature requirements and what IDs need to be presented, and whether people can harvest ballots and things like that. Lots of questions that were all settled at the state level in the states. And when Trump and his people or the GOP tried to challenge these changes and they worked themselves up into the Supreme Court came back down and said, states, do whatever the hell you want to do. Don't get us involved. The Constitution says that the state legislature is the appropriate body to dictate what happens with the elections. And because the Constitution says it's the state legislature and the states are supposed to do that, if the judges are changing the rules or the executive branch is changing the rules because of COVID and they're making all of these exceptions, well, that's not the Supreme Court's problem. That's not the federal government's problem, is essentially what they said. They said, deal with it in your states. And if you recall, the state of Texas sued Pennsylvania, I think it was Pennsylvania, and along with 12 or 16 other attorneys general throughout the entire country and said, hey, federal government, what you allowed Pennsylvania to do is impacting, it's not equal protection for our voting rights here in Texas. If Pennsylvania is allowed, hypothetically, to manipulate the votes and sort of, move things around and sort of seize power from the state legislature, take it into the court system, or in Georgia, allow the executive branch through the Secretary of State, Brad Raffensperger, to manipulate some of the underlying election rules. If you, Supreme Court, allow the states to do that, then they can manipulate their electoral results. And if that happens, then they can scam the election, essentially, right? They can move it around. Now, I'm not saying this is what happened, because it didn't. Joe Biden is the president, and we all love and thank that he's uniting America. But the point here is, hypothetically, if that happened, the Supreme Court now said specifically, we don't care about it. Texas, that's your problem. If you think that Pennsylvania is doing something that's not on the up and up, your problem. We're not going to get involved. And they declined certiorari for that case. They said, we don't want to hear the case. So now what happens? Well, now that Biden's in office, the federal government, through the executive branch, is saying, oh, now it's our business. Now it's our time to get involved in this stuff. And what the federal government is going to do through the Justice Department is criminalize the states that are now trying to conduct the audits, questioning the last election that had a lot of the rules changed by other actors in the state pre-November 3rd. Whew. All right, so there's a lot going on there. The point here, the feds are now interested again. Okay, so the Supreme Court, they were all telling us the states can do whatever the hell they want to do with their elections. Now, not anymore. Now, because they're up at the top, they're pulling the ladder up behind them, and they're saying, states, you're not allowed to go and investigate the preceding elections. Let's figure out what's going on here. Here is the document itself. We're not going to read the whole thing because it's a lot, but you'll notice that this is Joe Biden down here. Merrick Garland, the Attorney General. So they're in cahoots. Let's get into the document. It says, U.S. Justice Department is committed to ensuring full compliance with all federal laws. Got it. Includes provision that govern the retention and preservation of election records. So we've got two things we're going to focus on. Number one, right here, the preservation and retention of election records. These are going to be process types of crimes. And then number two, we've got this right here, that basically intimidation. Any activities that cause intimidation, interference, or interfere with a person's right to vote, those are going to be where we're focused, these two sort of broad categories here. The department is also committed to ensuring that our elections are secure. Listen to this quote. This quote is from a joint statement from the Federal Cybersecurity and Infrastructure Security Agency. They said here, look, folks, this is an official government document, and this is in quotes. It said, the November 3rd election was the most secure in American history. Oh, well, there you go. Okay, we're going to wrap this section up early because they told us that it was the most secure in American history. So should we go to the chat? Oh, gosh, okay. Well, just kidding, folks. In many jurisdictions, there were automatic recount or canvasses pursuant to state law due to the closeness of election results. None of those recounts produce evidence of wrongdoing or mistakes. Okay, and right, that's true, right? Perfectly legitimate election. In recent months, a number of jurisdictions around the U.S., an unusual second round of examinations have been conducted. They look at certain ballots, election records, election systems used to conduct the elections in 2020. These examinations are sometimes referred to as, quote, audits. They are governed, they say, under federal law. In some circumstances, certain exemptions may apply, others they will not. But regardless of the state law, federal law now imposes additional restraints. This document provides information about those restraints. Okay. So it's saying you can do those audits, but not if they are out of alignment with federal law. And federal law is saying, according to Merrick Garland, that we're going to be focused on these two big buckets. When we're watching you cyber ninjas, when we're watching any of you other auditors, we know that you're poking around here to come in and sort of investigate what went on. If you do that, we are going to be scrutinizing all of your efforts for two things. Number one, process problems. If there are procedural problems with what you're doing, specifically if you're not holding on to data. We talk a lot about chain of custody on this show, right? Person A gives it to person B. Person B gives it to person C. C to D, D to E, E to F. F gives it back to A. It's all verified and validated. If that chain is broken, well, you might have a problem. You can't really trust the integrity of that evidence because if A gave it to C, or sorry, if C got it and he got it from B and A gave it to B, but B is missing, Well, we got questions about what B did with that evidence, and we can't ask them about it because they're not in the chain. So we've got that, process problems. And what the government is going to be saying, if there are any process problems, well, you're responsible for those. Secretary of State from Arizona, if you give those over to that agency and something happens there, you're responsible for it. And that's just number one. Number two is if as a part of your audits, you are intimidating people, you're scaring them, if you're doing something that might cross over that federal statute against voter intimidation or anything that even resembles that, well, in doing your audit, your quote audit, you may be committing crimes and you're going to be responsible for that, according to the Biden DOJ. So let's dig into this. Where does this power come from? Where does the authority to govern all of this come from? You can see here, it comes from the Civil Rights Act of 1960, according to Garland. He says, this pertains to retain and preserve all records relating to voting, right? Section 301 of the act. So he goes in and identifies it. He says here, they got to hold on to those records for 22 months after the conduct of any election, including president. The materials covered by 301 goes beyond papers, includes other records. Jurisdictions then must retain and preserve the records. And if you don't, going to be a problem. So he goes through and he gives us a lot of other legal justifications, underpinnings for why this is allowable under the Department of Justice. And then we get to a conclusion a little bit. He gives us the basis. This is where we draw our authority. It's from the Civil Rights Acts and other things. And therefore, we get a conclusion. We get some analysis from him. He says, therefore, if the original election official, okay, so the person like the Secretary of State, the person who's in charge of running your state election, if they have custody of the records and they're covered by the act, and they hand those records over to other election officials, for example, to legislatures or other office holders, or the official turns over the records to private parties, such as companies that offer forensic examinations, right? This would be like cyber ninjas. So here, if the Arizona Secretary of State gives it over to another government official, or if they give it over to a private party, the department, the Justice Department, the department that's responsible for prosecuting crimes and putting people in prison and jail, interprets the act to require that if that happens, administrative procedures be in place, giving election officers ultimate management authority over the retention, including the right to physically access such records. In other words, the obligation to retain and preserve election records remains intact, regardless of who has physical possession of those records. What that means, folks, the Secretary of State, if they give those records over to anybody else, they're still responsible. Okay, so if they're transferring those things around, they've got to make sure that every single person who's touching those records is maintaining these obligations, right? They're comporting with the law. What does that do practically speaking? It encourages any election officials to not share anything, to not give it out to anybody. No, you can't see it. Why? Because if you do, if I give you these records and you screw it up, I'm in trouble. So how about I just don't give you anything? It chills the entire investigative process, and they know that's what's happening. That's why they're doing it. It's a procedural thing, right? Bury them in process work, make it almost impossible for them to actually process through the audits, because all of the record keeping has to be so robust that every handoff needs to be checked and monitored, right? And so now, I'm not saying that these audit companies can't do that, or even that that's a bad policy, but what's happening is that if they have to comply with those sort of regulations, certain people in this country they're already, not wanting to do audits, or not, wanting to sort of get that whole issue behind them. They're certainly not going to do it now if they know that the Justice Department is breathing down their necks. All right, so what else do we have? There are also federal criminal penalties that are attached to willful failures to comply. COVID crimes. Here you go, folks. We're straight out of the Justice Department. We got it in the congressional building, and now we have it right out of the DOJ. There are federal criminal penalties attached to willful failures to comply with, and this is that was for COVID. This is for voting stuff, but we're criminalizing stuff all over the place. Failure to comply with the retention and preservation requirements of the Civil Rights Act. Criminal penalties. First, Section 301 makes it a federal crime to willfully fail to comply with retention. 302 says any person, whether or not an officer, who steals, destroys, conceals, mutilates, or alters any record is also subject to criminal penalties. So conceals, mutilates, right? Violators of either section can face a $100,000 fine and imprisonment of up to 1 year. Look at this. For each violation. See that? For each violation. So the question then becomes, is it for each, let's say, batch of votes? Or is it for each individual vote? So what happens if you're analyzing, I don't know, 2 million votes? And you got 2 million violations. Then you got a $2 million fine, and also 2 million years in prison. So that's what the Justice Department is bringing down. Now, they give us some notes here. They say election audits are exceedingly rare, but the department is concerned that some jurisdictions, shout out Arizona, may be conducting them using or proposing to use procedures that risk violating the Civil Rights Act. Nobody wants to violate the Civil Rights Act. The duty to retain and preserve records necessarily means that they've got to maintain the chain of custody so there is a complete record. Election records are no longer... Okay, so this is the rest of the election record section. The second big bucket that I was talking about is this one here, intimidation. Okay, so the first one, of course, process problems. Now this says, this is going to be a violation of the Voting Rights Act of 1965 if you are doing something that is intimidation-like. What does intimidation mean? We get some guidance here from the U.S. Code. Knowingly, willfully, threaten, coerce, attempt to intimidate any person for any reason, right? So let's go into this a little bit more. It says the Attorney General can file civil actions to stop this, but there are also criminal penalties as well. So if you're doing, voter intimidation, boom, more criminal charges for that. So now if you're, wanting to audit this stuff, you're exposing yourself to a lot of criminal liability. Let's see what else is happening here. Judicial decisions have established that voter intimidation doesn't even need to involve physical threats. Now we need to know what intimidation actually means. In certain contexts, it could mean adverse social consequences, adverse legal consequences. Those can also be impermissible threats. So we have a couple examples here. And so the question is, as we're going through this analysis, are these audits voter intimidation, right? Because voter intimidation, we know, is illegal. It can be a civil rights, a civil claim brought under the Civil Rights Act or the Voting Rights Act, but it can also have criminal penalties attached to it. So, are the audits voter intimidation? Well, let's see. They're going to give us some guidance and they're going to tell us how some of this works. We have some examples from prior case law. This case comes from the Ninth Circuit, sending a letter to foreign-born Latino registered voters, warning them that if they voted, their information would be collected. That is intimidation, right? They're being connected to that. We have having police officers from the Fifth Circuit write down license plate numbers. That's enough to be intimidation, right? License plate numbers. That's intimidation. We also have sending robocalls, asking if they voted by mail. That could become part of a public database. That could constitute intimidation. Linking individuals to illegalities in a way that might trigger harassment could constitute intimidation. To illegalities, see that? Linking individual voters to allegations of illegalities might trigger harassment. That could also be intimidation. And how about conducting a ballot, quote, ballot security program where defendants stand near Native American voters to discuss whether they've been prosecuted? That could also be voter intimidation. So the question then, if we do the compare and contrast, if we say, hey, we know that the Fifth Circuit, the Ninth Circuit, South Dakota, West Virginia, many of these other states have said that this is what intimidation is. What the heck are they talking about? How does this apply to any audits that are taking place? How is that intimidation? Well, they give us some guidance on that. They say there have been reports, with respect to some of the post-2020 ballot examinations of proposals to contact individuals face-to-face to see whether the individuals were qualified voters who had actually voted. Cyber Ninja's statement of work, proposing to select 3 precincts in a large urban county to collect information from individuals through, quote, a combination of phone calls and physical canvassing. Guess what that was? Do you remember when Matt Brainard was calling all of the people and asking them if they still lived at that address and if they voted? He did that for tens of thousands of people, if I'm not mistaken, back in the immediate aftermath of the November 3rd election. Calling everybody, going through all of this data, phone banking. He raised, I think, $1 million or whatever to do this work. that would probably constitute harassment. He's actually now going out. Hang on a second. So, all right. So this sort of activity, let me just go back to this thing here. I want to finish this before we move on. This sort of activity raises concerns regarding potential intimidation of voters. For example, when these efforts are directed or perceived to be directed at minority voters or minority communities, they have significant intimidating effect on qualified voters. So there's a comment. So Matt Brainard and Cyber Ninjas or anybody that wants to sort of go and confirm and sort of, audit and test. Hey, do you still live there? Did you vote here? Did you vote by mail? Yes or no? All of those questions might be harassment. So you can't do those things anymore. According to the DOJ, jurisdictions that authorize or conduct audits must ensure that those reviews are conducted that with neither the purpose nor the effect of dissuading qualified citizens for participating in the electoral process. If they do not, the department will act to ensure that all eligible citizens feel safe. All right, if you have questions, give us a call. Also, if you have been subject to intimidation, you can use this complaint form. Give us a call, and we'll go prosecute whoever is intimidating you. Wow, so election audits are basically illegal now. That is from the Biden DOJ. Huh, all right, well, so we know that Joe Biden won the last election, so we can't talk about anything that questions that, as we know. But we are going to go into the questions, and so let's take a look at what is coming in over from watchingthewatchers.locals.com. All right, first one here is from Kincaid. It says, Rob, is there not a way to consolidate matters related to voting and audits? I mean, the legal system has not really allowed evidence to be shown. How can professionals keep a straight face? They know the difference between a resolution versus resolve. Framers accounted for tyranny and corruption. Why are not court officials speaking plainly for justice? I have a sinking feeling something larger than party disputes is playing out. Thank you for all the guidance and hard work. Thank you. Very nice comment, Kincaid. Thank you for that. My opinion on this hasn't really changed. And I think that the courts are still extremely reluctant to get involved in the electoral process. They don't want to be seen as being the arbiter of those things. And there's a long tradition here in law for some of this, that they just won't even address what are called political questions. So if you look into law and you look into constitutional jurisprudence, there's some types of cases that just won't ever make their way into court. And there are certain reasons why. One, well, the case is moot, right? You're filing a lawsuit, but the issue has already been resolved and it's moot. And so there are rules that say, well, if it's a moot case and it's not going to come back again, we're not going to hear the case. And so it's essentially a standing rejection of the case. There's no standing to bring the case in. You can also have ripeness, right? You're suing about something that's not ripe yet. It's not a problem yet. I know it's coming, but it's not ripe yet. It's not a problem yet. There are other questions that courts will just eject from the judicial process by calling it a political question. It's another standing sort of exception. They say, no, we're not going to hear the case. It's a political question. Go talk to your legislature about that. Go talk to your representative about that. And if you don't like their answer, vote them out. And then they're the ones that get to come in here and settle that, right? Even when we were talking about the 2020 election litigation, I was never anybody who said that I expected a judge to throw out 7 million votes or something like that. It was never going to happen because it was too much of an ask. There would have to be something catastrophically egregious for a court to come out here and say, we're going to take the entire constituency, all of your votes, and throw them out. And the courts, the judges are just not willing to do that. There's too much to... the Titanic is going one direction. It is not possible to reorient that without some serious data showing that it's impossible to deny it. And so that's what people are waiting for with some of these audits. We'll see what happens. We have It's Ed says, Rob, loving the show. Always look forward to it. Me too, Ed. I'm glad you're here. Says, so doesn't the Constitution outline the rights of the states to oversee their own elections? Yes, it does, including audits, at least. I thought the Supreme Court stated that regarding Pennsylvania. You did, Ed. You're on the right track. It's exactly right, which is what you have sort of the same, you're identifying the same contradiction that I am. It's that the feds said that the states should be allowed to change whatever they want because it's the states that get to govern their elections. that was when they wanted the rules their way so that they could unseat Donald Trump and put Joe Biden in. Now that Joe Biden's in, well, now it's okay if the feds come in and make sure that the states don't get too squirrely. When they were squirrely on behalf of the Democrats, that was a-okay. No problems at all. But now, if it's getting squirrely on behalf of the Republicans, the DOJ has to come in here and step in because that's the wrong kind of squirrely. It's not good enough. We have some other ones coming in from Want to Know. Says, Rob, I will testify that you have not mentioned anything about state review that Billy Jack was filmed in, except that which was already approved by CNN. Karen has a Twitter account too. I don't know what you're talking. Who's Billy Jack? I don't know what you're talking about. Want to know. Good to see you. We have I'm Not Gas says, how do the feds have any say in state-run audits? Well, they're basing it on the Voting Rights Act and the Civil Rights Act. I may not be a failed Supreme Court candidate like Garland, but my cursory reading of the Constitution says the state have precedent on election issues. Yeah, I know. And the U.S. federal government comes out and says, no, we're supreme now, and we'll see if the courts do anything about it. I agree with you. I read the same dang provision in the Constitution that you did too. I'm Not Gas, and it is perplexing. All right, let's see what we got. Some super chats. Let's make sure we don't miss these before they go away. We got Beth Coddington with a very generous super chat. Let's pull that up. Thank you for that, Beth. Says, hey, Robert, a bit off topic, but did you see 4 of the congressional overseers have tried to get into the D.C. prison where the January 6 prisoners were kept? First, they were told they were trespassing. Then they were locked out. I'll post on Locals. Awesome. Thank you, Beth. So I did see that. I saw that Matt Gaetz, I think Marjorie Taylor Greene, and several others went over there. And it was right as I was coming onto the show. So I didn't spend much time looking into it. You know, a lot of those things I think are political spectacles, right? I got to be consistent on that. Anytime these politicians do these, spectacle ops, it is that. That doesn't take away from the issue, okay? The January 6 defendants are political prisoners. We've talked about this a lot on this channel. Talked about the total unequal protection, the lack of due process that they are being afforded. And I've shown you the documents on this show. There are still people out there that are denying that, and we have the documents, and you can compare and contrast between what the Kavanaugh protesters got, between what Antifa or BLM people got. Even the people who burnt down the 3rd precinct in Minneapolis are sort of working their way through the system with less of horrendous conditions than the January 6th defendant. So you're absolutely right, Beth Coddington. I'm going to look at that story. Matt Gaetz and Marjorie Taylor Greene and a lot of them, they are showmen in the same way that AOC is or that Cori Bush is. And so it's just not my particular brand of politics. I don't know how effective it is, but I understand that it is very, very compelling. It's entertaining, and that's why they're very popular, right? They've got a lot of followers and a lot of heft out there in their respective positions. Good to see you. I'm Not Gas. We got a couple more. Sergeant Bob says, thank God Garland did not become a Supreme Court justice. Could have been around forever, but now at least he can hopefully be rid of him in 2024. It's a great point, Sergeant Bob. He was pretty close. They almost squeaked that one through, but McConnell saved that, didn't he? We have Thunder 7 says, hey, Rob, Matt Gaetz, Marjorie Taylor Greene, other reps went down. Yeah, got that. They were refused to visit, actually locked out. They gave a short press conference, said they'd never been refused visitation before. One was a retired judge. Is this illegal? So I don't know. So, I wish I would have spent a little bit more time on this story. It's hard for me to comment on it when I just saw it. Like, I think they were walking in when I was finishing my prep here. So I don't know the full story, so I don't want to comment on it right now. But it sort of depends, right? It depends on how they were approaching this. Like if they say, hey, let me in and go see the prisoners, then that's probably not going to be kosher, right? This is a prison. They've got all sorts of security protocols. I don't know what a congressperson, if they've got any, fast passes through security, but even for a defense lawyer, we got to jump through a bunch of hoops to get into a prison. I mean, we got to, do a bunch of stuff that's not worth getting into, but it's a high security, process. Okay. We have Moose in the House says, states need to stand up and say the Constitution gives control of elections to state legislatures. If states can do whatever they want per SCOTUS, lack of willingness to rule on state actions, then the Fed cannot exercise any control over the audits. To be consistent, SCOTUS must agree that states can perform audits as they see fit. Which states are going to stand up? Moose in the House with a great comment. Very good comment. And that's exactly right. right? And that's the consistency that I was trying to articulate, but you did a better job of it to me, right? It's consistency. Either it's the state's business or it's not. Pick one. They've already said it's a state business. So, well, the state should be free to conduct their audits as they see fit. Another one from Ghost of Lee Harvey Oswald. Ooh, spooky. Says, just wondering, do politicians still do motorcades? I can't read. Okay. All right. We have, let's jump over to let's jump over to YouTube and see what's going on here. We've got C. Reed is in the house, says, make 1984 fiction again. Thank you, C. Reed, for that. It's a little too close to home. We have Chris Wolney says, if audits are rare, how rare are certified auditors? Oh, that's a good question. I don't know. I don't know. Angela B says, so all of the Democrat and Rhino secretaries of state that have admittedly lost and misplaced 2020 election records are all facing prosecution? It's a great point, Angela B. It'd be a good question, right? And we know we have that 22-month deadline. So maybe all of the Republican pro auditors in their states should start auditing, or at least request that. Hey, Secretary of State Brad Raffensperger in Georgia, where are all those records? Where are they? Oh, you don't have them? Hey, Attorney General Merrick Garland, here's a copy of your guidance, your memorandum, and here's the name of the person who violated the rules. Why don't you go and charge them criminally? How about that? All right, good thought there, Angela B. We have Eddie Oliver says, could that same intimidation law apply to IRS audits? That would be cool. Yeah, so I think you're saying if an IRS agent calls you and they harass you, they get 1 year in prison and $1,000 fine. I support that. Yeah, I support that law. Kelly Ayers is here, says, so now the Dems are concerned with the handling of ballots, right? What an oxymoron. Time for this to stop. Every single Dem connected to the election fiasco should be in jail. One can only dream. Take a minute to picture free and fair elections. Well, they said we had that already. So I guess if we had that, then there will be no repercussions for anybody, unless you're doing the audits. There are no election consequences unless you're doing the audits. Then it is a problem. All right, we got another one from Super Iron Bob, just popped in, said, I hear poachers are having legal problems in Africa. Can we bring some in for our rhino problem? I'm sure they would make great election consultants. Okay, let's go. Thank you for that, Super Iron Bob. All right, let's fly through a couple of additional form questions, and then what time we got? Let's see what else is here. All right, Legal Panda is here, says Texas didn't state direct harm to the state of Texas. They laid out a bunch of hypothetical, which is of course true, but wasn't the point of the lawsuit. They forgot to connect what was alleged in the lawsuit to the hypothetical harm. By that, I mean, they didn't link word by word. I actually thought it was a very beginner mistake by Texas. I even saw it instantly what the problem was. So sad. That's from Legal Panda. And Legal Panda is I think you're onto something there, right? A lot of these lawsuits were missing a lot of that. Connecting, but they were all basically dismissed on standing issues. And part of the reason for that is because there was some sloppiness in connecting the dots. Not all of them, and I don't recall the Texas lawsuit specifically, but there were some others out of Nevada and some other states that I was reading, and I was saying, well, that's gonna go away because they're not, the person filing the lawsuit is not the person actually harmed. We have Interior Architect Panda says studio is looking much nicer. Thank you for that. I'm working on it and getting it cleaned up a little bit. Got to hang the sign on the wall and some other things. Jeremy is here with a nice one. Says, Rob, the Constitution, 10th Amendment says powers not delegated to the U.S. nor prohibited to it by the states are reserved to the states or to the people. Contrary to popular belief, the states have authority over themselves. Federal government does not have power over elections. Federal government needs to be reminded that a government by the people, of the people, by the people, and for the people shall not perish from the earth. Anything else will not stand. Love it. Thank you for that, Jeremy. Yeah, it's a good reminder, right? We often forget the federal government is not life. They're not. They want to be. They want to control everything, but they're not our lives. The states reserve a ton of power in this country, and we want to make sure we protect it. Got some other super chats coming in. Says, it was already state to state. Why fix wasn't broken? Good grief. Dems are selfish. That's from Lauren S. Yeah, state by states, we saw a lot of changes in many different states. And if you've been with the channel for some time, we were covering them before the election. We were going through and saying this lawsuit was won, this lawsuit was won, this lawsuit was lost, and so on. Bonnie Speck says, wherever rules Dems put in place will bite them later, like doing away with the filibuster. Yep. So they changed the rules to suit them, right? Get to the roof and pull the ladder up so nobody else can get up behind you. And then Manners says, Rob, can you explain how far one can go without being considered an insurrectionist? As in, is liberty or death a crime to believe or say? R. Jefferson quotes. You know, it's a great question, and it's a very interesting question because we are seeing certain people in this country talk about anti-government rhetoric as being insurrectionist or as being language that domestic terrorists use or the domestic violent extremists, right? Maybe you're not a terrorist yet. That's kind of a serious category. Maybe you're just a domestic violent extremist. And a lot of that language, you know, things like Jefferson, things like saying, well, you know, the tree of liberty needs to be refreshed from time to time with the blood of patriots and the, however the rest of that goes. Those phrases might be problematic, a little bit scary. And it is something that's we've got to deal with, don't we? All right, we got some other questions coming in. I got to pick up the pace a little bit because we still have a whole segment. So let me take that one super chat. I think two came in. Another one came in from Zulu, says, could latches apply even if they don't file against audit fraud before the results are released? Could latches apply if they don't file against audit fraud before the results are so I think you're asking, Zulu, if the feds, I apologize, Zulu, I'm not sure what you're asking. I think you're asking if the feds file against like cyber ninjas, for example, if the feds filed against them before the results are released, could they use latches to keep the results from coming out? I think that's what you're asking, and I think the answer would be yes, right? And I think that a judge would very likely find in that way because this is now the new guidance from the Department of Justice. So it's a great question. So they could actually, you know, theoretically go after now on this basis, saying, hey, this is how we're interpreting the laws. This is guidance for you. And so, you know, if you continue to do this investigation, we are going to file a criminal complaint against you, and that would subject you to seizure of all of your work product, essentially, right? Anything that you got in violation of the law would be subject to confiscation and be impounded as evidence. And so maybe you could really actually shatter the perceived legitimacy of the underlying audit by doing that, right? Because you can kind of go in there and interfere with their audit that's taking place right now, allegedly, according to them, in this sort of closed door environment, right? The reason why people have problems with the audit investigations taking place is because everybody is saying that every part of the investigation is compromising the evidence. When the auditors want to come and get the official documents from the custody of Arizona or whatever state is doing the audit, well, they got to take custody of that, which breaches the chain of custody. And so anybody who doesn't want the audits to move forward starts to scream foul, right? Foul game on that, because now you broke that. And so now what the auditors would do if the DOJ comes in and interferes with that line of investigation as well, then they'll say, well, you breached our protected environment and you're breaching our chain of custody. And so they may say that, you know, the results that they were intending to report are going to be different, are different now because the DOJ sees some evidence. But I see what you're getting at, that this might be sort of a wedge in order to start legal proceedings towards the cyber ninjas on the basis that the new interpretation of the rules pursuant to the guidance justifies criminal complaints being filed. It's a great point, great question, Zulu, and we'll see where that goes. Maybe that's what they're doing. Good observation on that. All right, great questions. Thank you for all of those and all of your love and support, both on Locals and on YouTube. I appreciate you all very, very much. Okay,